Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Mr. T.
Good morning, Mr. Chief Judge Gregory, and may it please the court. My name is Derek Teedy, and I represent the petitioners on this petition for review. In December of last year, the West Virginia Department of Environmental Protection purported to make a predictive judgment that the Mountain Valley Pipeline could be completed without further water quality standards violations in West Virginia, notwithstanding the company's long history of such violations and the absence of any tangible assurance that the company had changed its ways. Based on that prediction, DEP issued the Clean Water Act Section 401 certificate that's the subject of this petition. DEP's prediction, however, was not reasonable based on the record before it. For that reason, among others, DEP's certification was arbitrary, capricious, otherwise not in accordance with law, and this court should vacate it. But I'd like to start this morning with the threshold question of whether the agency action was final, because the state, although not MVP, contends the certification was not final. The state is wrong. The state has confused the concepts of finality and effectiveness. A delayed effective date is not sufficient to render an agency action non-final. An agency action is final when the agency has completed its action and when legal consequences will flow. Here, the certification was final on its issuance. DEP said that it had completed its consideration of the application and that it shall become effective without any further action by DEP in 15 days. And legal consequences were also immediate. As the D.C. Circuit held in Alcoa Power Generating, Inc. versus FERC, and that's at 643 F3D 963, a federal agency is...
So then what is the import of the shall become effective within 15 days if legal consequences were immediate?
You know, I'm not exactly clear why that sentence was in there. It may have been to allow a time for the appeal to be filed. It happens to coincide with the opportunity to request an appeal. It is not required by state regulations. It is not present in every West Virginia 401 certification, yet it was present here. But regardless, as the D.C. Circuit has said, a federal agency can issue a license or permit even if, upon the issuance of a certification, even if the certificate is not immediately effective. And the administrative review process to which the state points is irrelevant for these purposes. There is no requirement that administrative review be sought. Rather, it's discretionary. A person may seek a hearing. Moreover, that appeal is not as of right. The Secretary of DEP has the discretion, apparently from the regulations, the unfettered discretion to decide whether or not to have a hearing. And most importantly, there is no stay in the interim. As we can look to federal finality doctrines for guidance here. The federal APA provides that an agency action is final unless it is rendered inoperative during an appeal. That's what the Supreme Court held in Darby versus Cisneros. And as there is nothing in the state's regulations that would apparently even empower the Secretary to stay the effect of a certification pending the appeal. So for all of those reasons, this decision was final. Turning to the merits, DEP's finding that there's a reasonable assurance that the pipeline can be completed without violating applicable water quality standards is arbitrary and capricious because it was entirely implausible and internally inconsistent. The certification at JA 56 says, without information demonstrating otherwise, the DEP relies on compliance with the requirements of its stormwater permit to control discharges from construction activities as necessary to meet applicable water quality requirements. Well, here, there is information demonstrating otherwise. DEP found MVP had violated that stormwater permit when it was in active construction 139 times and committed nearly 50 water quality standards violations. Now, DEP nonchalantly says, well, it does not regard the number of violations its inspectors issued as surprising. But frankly, DEP defies logic when it says in one breath that MVP's compliance with the stormwater permit will prevent water quality standards violations, and in the next says that MVP's violations of the stormwater permit are not surprising.
Cut to the chase on what you're arguing here. Are
are you essentially saying there were past violations and now there are conditions, but there's nothing there to show that there would be no future violations based upon the department's determination?
Yes, that's correct. There are no new conditions. They speak of enhanced measures or more frequent inspection.
Why is that required?
Well, because it's arbitrary and capricious for an agency to make a predictive judgment and ignore the past. And that's the Bell South case that we cited in our reply brief. When you're making a predictive judgment, if the past actions are relevant to that prediction, well, then you must consider them and explain why this time it will be different.
So is your problem, because they say they considered them, your problem is they didn't explain it?
Well, it's unclear how closely they considered them because DEP, in response to comments about water quality standards violations in the past, DEP said, this, and this is at JA 72, the subject of the current certification request is whether the information provided by the applicant satisfies the regulatory requirements. The previous actions of the applicant are not the subject of this review. So I don't think the DEP really took them seriously. And to the extent...
So are we in a weighing situation when your opposing counsel gets up and he says, well, they did consider it, and you got to do predictive judgment on this here, and this is what we do. And this was the way in which they undertook it, was to make a predictive judgment here, and you should maybe give some deference to this department in doing it. How do you respond to that?
Well, deference is inappropriate when an agency action is inconsistent with the record below. And to the extent that DEP did consider the past violations and characterize them as minor, that is inconsistent with the administrative enforcement actions that DEP brought.
So how difficult this would be if we sent it back on that for them to fix it? Do they simply just amend the record and says, well, we consider these violations and we consider that X, Y, and Z are here to protect against future violations? Does that cure it?
I think it would take a reasoned examination of what MVP intends to do differently to ensure that violations do not recur again. All of the enhanced measures that they speak of.
But I'm really getting to, and I guess maybe I've just been up here too long as a judge, but I'm looking at the reality. Send this back. They go back in a room, re-look at the record, and then enter these additional things that you think should be in the record. Does that cure it?
It could cure it, depending on what those things that they enter in the record are. If they provide a reasoned explanation for why things will be different this time.
Can we do that? Can we look at the record and do, in short circuit, can we just look and say, well, let's look at this here and see, do these things really show something there on that nature?
I don't think that you can. I don't think that this was a harmless error because there were violations that occurred. DEP notes that several of them occurred at water crossings. One in particular is noted in the JA at 1862, where water quality standards violations occurred at stream crossings. We need to know what are they going to do to make sure that these violations do not occur again, and it's not enough to wave away the violation history. So I don't believe that it is harmless on this record. I don't think you can look at the record and see that MVP is doing anything new. All of the enhanced measures that they talk about were present in 2017. In the JA at 2129 to 2133, there are a series of construction plans that lay out what were called enhanced BMPs, and it's dated 2017. These were things that they had planned on doing from the get-go and that have proved ineffective. And it's for that reason that the record wouldn't be sufficient to say that this error was harmless.
So you make 5 arguments here on the merits. What
Yes.
are your top 2?
What are the top 2? Well, the failure to, I love all my children equally, Your Honor.
Yeah, but it always...
I only got, 6 minutes to show my love today. I think this violation history argument is very, very important. I think also emblematic of the irrationality of the agency's argument is its reliance on EPA's position on upland construction. DEP said at least a half dozen times that it was relying on EPA's view that BMPs, best management practices, sorry for the acronym, protect water quality during upland construction to conclude that those best management practices will prevent water quality standards violations. In fact, DEP said it has first turned to EPA and its stormwater construction permit. The problem for DEP is that the permit on which it relies, EPA's construction stormwater permit, does not and cannot regulate Section 404 in-stream activities. to the extent that EPA guidance could be appropriate here, right? In fact, EPA's 401 regulations provide, they tell states, hey, we are available to consult on ways to predict whether or not water quality standards will be complied. If you have questions about how to apply your water quality standard or a particular project's impact, we're here, pick up the phone. And those regulations were in effect under the old regime. The old regulation is 40 CFR 121.3. They're also in effect under the 2020 401 regulations.
So the department says, at least in a brief here, that it just never believed that general permit applied to the in-stream construction.
That's inconsistent with the certification itself is the problem. If you look at JA 65, on that page, DEP says that the EPA permit extends to both upland and water crossing activities. So its position in litigation that, we knew that permit never applied, is inconsistent with the record, the certification itself. And so it seems to be a litigation position of sorts. And its reliance on EPA was repeated. It wasn't just an offhand comment. There were at least a half dozen times.
So where is the inconsistency? The inconsistency is there. Where is it coming from? It's coming from the same people, or is it a intervener, or is it the department, or who? How does that inconsistency come about?
Well, the inconsistency is their litigation position that, we never thought that it applied to upland, with their words in the certification itself, where they said that EPA's permit extends to both upland and water crossing activities. But as a matter of law, that permit cannot apply to water crossing activities. Those are Section 404.
Is it really possible to engage in these water crossing activities, building this pipeline, without some water violations?
I believe that it should.
Or is it just the, all right, go ahead.
Or I didn't mean to speak.
Or is it just the amount of violations that have occurred and continue to occur here that you really have a problem with?
Well, we have a problem with both. We think one violation is too many, but in this case, we've seen, nearly 50. But the Clean Water Act, as this court has held, is a strict liability statute. I believe it's the American Canoe case where this court held and has repeated since that its standards, that strict compliance with the water quality standards are required.
You haven't mentioned that there have been violations since this August 2022 violation that are the subject of 28J letters. Are you abandoning that we need to consider that?
No, I do not abandon it. I think it shows, it is evidence that proves the falsity of the reasoned prediction that there was some enhanced or new measure that was going to prevent future violations.
Can we rule in your favor without considering the recent violations?
I think that you can. I think that you can. But there was a point made by MVP in its response brief that, violations had tapered off or ended by 2019. And this goes to show that that's not the case. That's not true. The violations are still occurring. And while we're speaking of the 28J, that comes to another point that the position has been that MVP responded to all of those violations immediately, I believe is the way that it's been phrased. But that's inconsistent with the administrative consent order, where the penalties for multiple violations were enhanced because of the length of time that the violations persisted. And in both of the 28J responses, both MVP and MVP say that August 11th one was immediately corrected. That too is inconsistent with the record. If you look at the inspection report for that violation, this is document 86-3 at page 1, the inspector wrote, it couldn't be clearer, not immediately corrected. So the excuses that DEP provides for the violations that have occurred simply aren't supported by the record. Coming back to EPA just for a moment and their reliance on the EPA stormwater permit, it's remarkable that the agency, if it needed guidance from EPA, it could have reached out to EPA. Alternatively, it could have looked at EPA's comments on this very project. EPA reviewed MVP's application and provided comments to the Army Corps of Engineers in which they said EPA, this is at JA 1067, EPA is concerned that the applicant has not yet demonstrated that the discharges from the project as proposed will not cause or contribute to water quality standards exceedances. The same agency that in DEP's view thinks that BMPs are a cure-all to protect water quality standards on this very project and on MVP's very plans noted that it had concerns that water quality standards would be violated. DEP didn't look to that letter, didn't address that letter or the project-specific comments, and instead looked to the inapt stormwater construction permit. I see that I'm running short on time. I'll just briefly conclude that this court observed in 2018 in a case involving water quality that West Virginia has long resisted the requirements of the Clean Water Act, and we would submit that this is just the latest incarnation of DEP's resistance. If there are no further questions, I'll step down. Thank you.
Thank you, Mr. Tini. Ms. C.
Thank you, Your Honors, and may it please the Court. I'm Lindsay C. here today on behalf of the West Virginia Department of Environmental Protection. Of the many requirements for a complex project like the Mountain Valley Pipeline, Section 401 certification is an area where Congress has been clear that state discretion matters. It involves a state agency making highly technical assessments when applying state law. And here, DEP took that role seriously. Over a 10-month process, it engaged with hundreds of comments, reviewed its own and other agencies' detailed assessments of the same project, engaged MVP's data, asked for more, and ultimately required a new detailed mitigation framework and 30 other special conditions before granting certification.
You have these specific conditions that are included in this certification. The issue before us, it seems to me, your opponent has presented is, are those sufficient? In other words, where is it in those conditions? It's stated that there's some intent to deal with future violations based upon the past conduct.
Certainly, Your Honor. I think it's important to look at two questions that the department was engaging there. The first is whether the past violations was enough to say that no permit would be possible, and the second, was it irrational that the new conditions here would in fact deal with those. So I can start with that second one, since that's what Your Honor asked.
Well, even with the first one, you say about the past, it's almost like you say in your brief, they were minor. But at least the consent orders characterized them being major.
Your Honor, I don't think that that is entirely fair what the consent orders say. The same page that petitioners cite that talk about major deviations, talk about deviations from the permit, but that exact same table says that the potential for harm from those violations were minor to moderate. So even if we look at that consent decree itself, which of course is not acknowledging or admitting to any wrong, but even there the terminology shows that there was only a potential for harm and it was minor to moderate. That is one of the ways that the EP looked at these past violations. Petitioner has recognized that it would be possible, even under their view, to grant a permit as long as the department sufficiently engages with the conduct.
Does the potential to harm matter?
Certainly the potential for harm does matter, and that is a factor that the department looked at. It looked at that as one of several factors. It looked at the number of violations here and said given a project of this complexity and how long it's been going on, the number was not surprising. It also looked to this court's analysis in this first State Water Control Board case that says it is to be, quote, anticipated that there will be a number of minor issues from a project of this size.
You said the numbers were not surprising. What is the metric of your tolerance?
What we are looking at under the 401 regulation is whether there's reasonable assurance that the methods going forward would be enough to protect state waters. And that is what the department said here. It looked at a number of factors that are going to protect West Virginia's waters. It looked at a separate operational oil and gas construction general permit, the enhanced site-specific best management practices that MVP gave and the department approved there. It also looked at the new mitigation framework, which is something that did not exist at any earlier stage. And it put 30
What
others.
is the new mitigation framework?
I think we can look at several factors in that mitigation framework. It's discussed starting around JA 128. That is a multi-step process where, first of all, MVP is required to have detailed site-specific baseline assessments for all of the particular crossings going forward. That's in addition to the site-specific assessments in the application. MVP provided that information in November 2021. The framework also requires there to be site-specific construction metrics and performance standards, and then to have continuous monitoring during construction, then ongoing monitoring for a period of 3 years to ensure that that actually occurs, and that to support the department's predictive judgment that any impacts would only be temporary. This is something that didn't exist at any earlier stage in the proceeding.
But don't you limit the oil and gas effectiveness as to restoration, but not necessarily ongoing trenching? Is that correct? The application, you specifically say it deals with to the extent of restoration, right? What about ongoing? Is that correct?
No, certainly the mitigation framework is looking at restoration, and that's where the 3-year monitoring comes in, but it's also looking at the particular conditions before any of the construction starts. There is, of course, inspections that occurs both during the active construction period. That's once a week while there's active construction, and then there's inspections that occur once every 14 days in the restoration period. So this is a comprehensive certification that looks at how construction activities take place, as well as how restoration is in fact going for years to come. This is a question of what is enough, and these are highly predictive judgments that...
But doesn't that limit the application to looking at what they're doing while they're doing these things? It says restoration. Restoration wouldn't involve the blasting involved, the trenching. Why would West Virginia do that? To protect this environment, the clean water.
Well, West Virginia is certainly concerned about mitigation effects in the same way Virginia was, for instance, in the State Water Control
Would you
Board.
answer my question is why would you restrict it to restoration and not being strictly compliant, being applicable to ongoing construction? Wouldn't that be a time where there'd be quite a bit of potential damage when you're actually doing the blasting, doing the digging? Why would it be restoration? And it specifically said, to the extent it is involved in restoration. And that's language that West Virginia put in?
West Virginia put that language into...
Why?
Well, I want to be clear first that that is not the only thing that the certification is dealing with. There are many conditions and best management practices for construction. So this is not...
No, that's granted. Well, answer my question if you can.
So if I'm understanding it correctly...
But why did you put it that it was restricted to restoration for the third time? Restoration and not to the ongoing blasting and the trenching that's going to be done. That's just a simple question.
Well, we did not restrict the best management practices simply to restoration. Most of them do deal with the dewatering process, the blasting, the trench process. So many of the conditions, most of what takes place in the general construction permit all deal with that first part that Your Honor is talking about. It is true...
But most of those were already in place prior to this permit. So how are they enhanced practices when they were already in place?
Many of them
These are
weren't...
not new things.
Correct, and I want to clarify, the enhanced practices language, that comes from the stormwater prevention permit, which of course did exist before. Those were enhanced best management practices that MVP submitted, the department approved when originally giving registration under the certification. It's not irrational for the agency to say that some of those pre-existing conditions and requirements would still help it have reasonable assurance going forward.
Unless those things that were already in place had resulted in 149 violations already. So how are those things that were already in place, which resulted in all these violations, reasonable assurance that there won't be violations going forward?
I think
you have to look at the past as a predictor of the future.
Yes, Your Honor, and the department is not disputing that. I think there's two important ways to look at that. The first is looking at those 149 violations. If we look at what the department said on JA 69, it made several types of predictive judgments about them. First, it did...
JA what?
JA 69 is where that discussion starts. That there the department looked at the number of violations, it looked to this court's reasoning and said the number we're talking about is not surprising given a project of this size and the years involved. It also then looked at the nature of violations. Petitioners have looked at that major language from the consent decree, but what they can't dispute is the department's finding that the overwhelming majority of these violations involve permit violations and had, quote, no aquatic effects. Now, certainly the department is not tolerating permit violations, but that also shows the process is working how it's supposed to. The permit is a prophylactic system to make sure we're putting additional measures in place to make sure we don't have violations of state water quality.
So of the 149 violations, how many had no aquatic effect?
The certification does not give the exact number on no aquatic effect.
Then how can you say the overwhelming number had no aquatic effect? That's what you just said.
Yes, of course, because
I'm trying to understand what an overwhelming number is. Back to Chief Judge Gregory's question about West Virginia's level of tolerance for violations of its waters.
Correct. There's no number for the no aquatic effect. The number we do have is there are 50 that were not simply straight permit violations. And in those cases, we have circumstances where there may have been a discharge that went outside of the permitted disturbance levels or into state waters. But even those, as the consent decrees show, even in that smaller number, the potential for harm was minor to moderate.
You know, when the opposing counsel brought it up, the fix of this situation is not difficult, at least from his perspective. It potentially could not be a difficult thing to do. When you have past violations, characterize them as minor or whatever, 149, some are not so minor, it appears, and then you come back and you give the same certification with the same kind of protections, and what's missing is the explanation in the record as to how these conditions were specifically tailored to address the past problems. That was the question I asked the opposing counsel. Well, what do? We just send it back, and the department, seems like to me that's what you do. Just go back, look at the record, and not put you through this torturous argument of, well, these are just little minor violations, and we'll just dismiss them as minor, which goes to say, well, we did all that. Why do we do all those other cases in here if they're just minor violations? When the simple fix is, if you're going to impose conditions, then just indicate how they are tailored to fix the problem. And I think it's a language problem. And it may be that they can do it for the record. Maybe there's some way to do it. But don't you think that if ultimately it does go back, this should not be a difficult matter to resolve?
I do agree with that, Your Honor. Let me take a run at explaining why there are new conditions here. I think if this is a matter of lack of explanation, we would disagree with that.
There's no question you got new conditions. What you don't have is the explanation as to why those conditions are specifically tailored to address the past problems. That's the line we're drawing here. At least me, I'm trying to understand, where is that? And, council can look back and, 50-50, go back and say, well, we see we could have done this. Well, from at least it seems to me, that's a pretty easy fix. Either do it or they can say we did it or we didn't do it.
Your Honor, I do agree that in the particular portion of the certification response to questions on past violations, it doesn't specifically tie the new conditions there. I agree with that. I also agree that it would be an easy fix, and I think that would be a reason not to reverse because, as this court has said in the Roe versus DOD case, as long as the agency's path can be reasonably discerned, that's enough for a reasonable explanation. This is not
not to reverse, but to remand.
Correct,
Yeah.
yes, to remand. And I think we can reasonably discern that path here. If we look to the other portions of the certification that talk about the new conditions, we can look at a couple of them, for instance. Something that's new is Condition 2 that talks about the requirement to look a half mile upstream for all intakes. Condition 4 puts more specifics on the details for revegetation and allowable and disallowed materials. We have a number of new conditions here that are specifically addressed to make sure that we do not have violations of state water qualities going forward.
But you say that sounds good, but does the department say it?
Your Honor, the department does say that in the conditions. It imposes the conditions, and it says that that is necessary in order for it to have reasonable assurance that there will not be violations going forward. If what the court is looking for is the magic words that say, and because of these conditions, that's why we think that we have confidence in light of...
What's Condition 4? Does that go to restoration, revegetation?
Some of that goes to restoration, but it also looks at the particular materials that are allowed to be used during construction. So yes, we do have a mix of conditions.
Such as?
I do not have Condition 4 right here. It talks about certain types of metals that are not allowed to be used because they're more likely to leach into the water system. It gives an illustrative but not exhaustive list of materials that can and cannot be used. So that's what that particular
Materials
condition looks
used
at.
for what operational point?
Materials used for the construction process itself. So we're talking about both construction and mitigation. So the department was very concerned about both of them.
What introduction of metals, because you made that example, what introduction of metals that you're protecting that would assure there are no violations in that area?
Well, some of these are dealing with best management practices. We want to make sure that when the water is restored back to the original stream bed, that there's not going to be an introduction of harmful materials to the water systems. That's one example.
That's a post. Isn't that a post-construction matter?
Well, that's.
You're not talking about the actual materials they use to dig, are you?
We are in that provision, but there's many others that are dealing with those as well. So that's only one example here. But yes, we're looking at some of the materials used in the actual construction process.
In blasting? I'm just trying to find, when you say things like that, I'm just trying to get to the nub of it. What materials would be introduced in the blasting and the digging that you now have made sure that those metals will not be introduced? Tell me what that is.
Your Honor, I think I understand the confusion. I'm not talking about the materials for the blasting itself. I'm
You're talking about materials
for constructing the pipeline itself. So some of the process that's used in laying the pipeline and in isolating the area to make sure that there's not going to be any introduction of harmful materials. But again, this is one of the many conditions we have here. Most of the ones that were relied on were, of course, in the original construction general permit. We do have many best practices that not only DEP, but FERC and the vast majority of peer-reviewed studies have shown are highly effective when it comes to this sort of construction activity. I think it's important not to lose sight of that. We're talking about in the dry, open cut crossings, and that's not something that the department said we can tolerate even though it's a bad idea for the environment. There's specific findings in the certification that extensive studies show that any effects from them are only temporary and that they are in fact not going to violate state water quality. That's something that FERC held in its original environmental impact statement, that EPA did as well. So there's nothing irrational about the department's conclusions here when it came to the particular project before it.
And I would assume you tout the mitigation framework restoration part being the new part that's helpful.
I do think that that is the strongest, the most, the clearest example of something that is new and that is helpful. The title, I think, may be a little bit misleading. Of course, it deals with mitigation, which is an important part of the problem, but it also deals with assessing the baseline conditions and setting site-specific performance standards. So I would direct the court to that. I think that is the best example, but that's not the only example.
But it's the best example, but it doesn't set out any specific mandatory criteria under oil and gas, does it?
Well, certainly the mitigation framework is mandatory. That's condition 26 of the certification. This is not just a voluntary measure.
It's mandatory in terms of it says with compliance with all state and federal law.
Well, state and federal law is mandatory, but complying with the particular six-step mitigation framework is a mandatory condition.
Under the oil and gas, right?
No, under the...
That's what I ask you. Why it doesn't, does it?
No, I'm sorry. Under this certification, this is condition 26 of the 2021 certification. So it's not something that existed under the general oil and gas permit. So that is something additional that the department required MVP to comply with going forward that didn't exist before this certification.
But ongoing, would there be a conflict in the sense of what would apply in terms of ongoing, whether the state oil and gas preempts in terms of regulation of pipelines, is that right?
No, Your Honor. I think the preemption argument, that goes to the separate point, if I'm understanding,
right,
of whether the department was required to specifically incorporate the oil and gas permit. The only argument that it would be necessary would be because of this hypothetical preemption concern. But the department would have very strong arguments that its permit is not preempted because of precisely what you pointed out, FERC's requirement that MVP comply with all applicable state permits. So a highly theoretical preemption
argument. Well, the Second Circuit said that wasn't enough, didn't it?
Certainly there is some case law that goes the other side on the preemption issue.
So you want us to create a circuit split on that issue?
I don't, Your Honor. I think this court only needs to look at what it's held before, that when it comes to what conditions the department is required to put in, there's a wide degree of discretion there. Of course, the department could certify with no conditions. The department has to put the conditions in that it thinks are reasonable or desirable. The department looked at this and said that we do not have to put this redundant condition in here because MVP already has to comply with this permit. So it's not necessary to explicitly say that again because they knew they were already doing it. Yeah. The only concern would be preemption, and again, because that's theoretical and the department would have very strong arguments the Second Circuit is wrong, that's not enough to take it out of the realm of discretion and make it necessary to include. I see I've gone over my time, so unless there are any other questions.
Thank you, Ms. Sibley. Mr. Sibley.
May it please the court, George Sibley for Mountain Valley Pipeline. I'd like to first start with petitioner's contention today at the podium that there's no tangible assurance that MVP has changed its ways. That claim is wrong. In response to each of these violations, Mountain Valley was required to submit a corrective action plan. DEP reviewed those plans and they approved them. In each instance, Mountain Valley took corrective action, including in many cases installing additional controls to ensure that there were controls in place to address the issues that had been identified. We provided a list of that in our 28J response. This contention that Mountain Valley has done nothing in response to these violations is one that appears for the first time in the reply brief, so unfortunately it's not in the joint appendix, but you have it in front of you now in our response to the 28J letter. That table lists the corrective action that was taken, and in many cases, Mountain Valley is installing additional controls at the direction and under the supervision of the state to address the specific issues that have been identified. It is also...
Speak to council's argument regarding 401 certification as being arbitrary and capricious because the department erroneously believed that EPA's construction general permit endorsed the use of the best management practices for in-stream construction.
That claim, Your Honor, is one that is the EPA's construction stormwater general permit does not control the specific discharge of dredge or fill material into streams. That much is correct. But the permit does regulate construction activity right up to the water's edge. In addition, that is a passing observation. It is one of several bases on which the agency bases its decision. As my friend noted, during the review process, the agency reviewed scientific studies, not simply those that Mountain Valley provided, those provided by the petitioners as well. And this concludes.
Tell me about the position you're taking in your brief, which seems apparent. You're saying that never believed that the EPA's guidelines applied to in-stream construction, but the record belies that. There's a statement in that where DPA basically says it did believe it applied to in-stream construction.
And to that extent, Your Honor.
If you don't mind, I'd like to finish. Is that not an inconsistency in the record?
That may be incorrect, but that is truly a hard.
If you will. I'm not trying to trap you in anything. I'm just asking for facts. Is that an inconsistency? We typically don't like inconsistent statements before the court, whether they're relevant, minor, or whatever, but it is something to represent to us that it doesn't apply, and then the record indicates you do say it applies. Is that not an inconsistency?
I would. The stormwater permit does not apply to actual in-stream construction activities. And if that was the only basis on which the agency made their decision, we might have a problem. But it is not. These construction techniques, the actual subject of this certification.
You have other things you can rely upon. I'm simply dealing with the integrity of the process here, and it may not affect it one way or the other. But I just want to be clear that when you come here, you do not make assertions here that are inconsistent in the record. It seems to indicate we don't read the record. And I ask you pointedly, that is an inconsistency. You do acknowledge it, and that's fine. And you can explain, how it's, even though it appears to be inconsistent, et cetera. But when the record itself contains one statement and there's other, it may seem minor to you. We take those things serious because it goes to, I wouldn't say credibility, but it certainly goes into why we need to get hung up on that if that's not something that really needs to be dealt with.
In the short time I have left, I may speak to credibility.
You will have some time. You will have some time left, but I simply want you to address where I'm going with it. Don't worry about your time here. We're going to give you a fair opportunity to speak. I'm simply saying let's move beyond this and accept it, and then you can move on. Carry on.
On credibility, petitioners claim that the mitigation framework is not new. That is wrong. The requirements in the mitigation framework, and Chief Judge Gregory, to your question, they involve requirements that regulate the construction activity itself. It requires Section 3.1 of the Restoration Work Plan, requires continuous monitoring during construction to ensure that the controls put in place are working to prevent the mobilization of sedimentation downstream. That is a new requirement. The requirement to collect baseline data is a new requirement. Petitioners know this because they lament the absence of that data when they critique the way the agency assessed the effect of restoration activities at completed crossings. These are new requirements. These are part of the basis on which the agency could draw reasonable assurance that the issues that have occurred in the past, in addition to its ongoing monitoring of the site, to
And
remember,
both of those are during construction as opposed to restoration?
those are during construction, Your Honor.
Continuous monitoring, and what was your second one?
Continuous monitoring, the requirement of a field meeting before construction commences so that everyone knows exactly what's supposed to be in place. The obligation for people to stop work if controls are not working properly. All of this is in, the restoration work plan is from JA 208 to 221. I urge the court to read it in its entirety. That is a powerful tool that the agency has put in place.
But if it's called restoration work plan, it sounds to me like it's during restoration rather than construction and trenching.
The label of it probably could have been better. But
Okay, so it's called restoration work plan, but it's really covers everything.
absolutely.
What JA site was that?
JA 208 to 221. You cannot improve monitoring beyond continuous. And that is the subject of this certification, water quality, the actual stream crossings themselves. Now, the agency here, the specific question is whether these crossings can be completed consistent with state water quality standards. And there was substantial evidence in the record on which the agency could base that
And
judgment.
you're saying this entire restoration work plan is new
Yes,
after the
yes.
permit?
Yes, it was implemented during this permitting process. Petitioners raised the fact that EPA raised concerns and raised comments. This is one of many things that was done to specifically address EPA's comments.
But the question is, beyond that, Mr. Sibley, is that may be a change, but the question is compliance and enforcement. While on one hand, it includes those things you talked about, the other hand says, only to the extent it's restoration for compliance. That's why I wonder why these things, why would that language be there?
Chief Judge Gregory, I don't know where you're getting that language.
Okay.
I don't know where that's coming from. We are required to comply with this during construction, and if we're not, we're out of compliance
But during
with the
construction,
mitigation.
what about after construction in terms of, what about after construction in terms of being able to enforce it?
Well,
Are you sure that the language, you're saying there's nothing in the mitigation framework, there's no language that restricts it in terms of, to the extent it's restoration? That's your position?
yes.
Okay, all right.
And post-construction, that we have a three-year monitoring obligation, using that very
How long is the
data.
pipeline gonna be there?
Well, to make sure that the crossing, the
No, no,
pipeline's
no.
going to be there for decades.
So 3 years is,
Well, it is, but Your Honor,
Drop in the
again,
bucket?
we're measuring whether the actual construction activity has been fully restored. Once we've achieved those performance metrics and we've achieved final restoration, you don't need to monitor anymore for water quality standard violations. Certainly, that's the judgment. Judge Wynn, if I could, I realize I'm significantly over my time. I'd like to address your question concerning the extent to which the agency explained itself. This court has repeatedly said that, and indeed this very panel has said, that an agency's failure to address an issue in as great a depth as a panel might like does not render the decision arbitrary or capricious. With respect to Mountain Valley's violations, the agency addressed the question. You cannot say they entirely ignored it. And the evidence shows that Mountain Valley its track record has improved. Now, we unfortunately are still had a violation in August. We're driving that number down to 0 as best we can. But as conditions occur in the field, that's sometimes difficult to achieve. The agency might have done more to address that, but that does not render the decision arbitrary or capricious.
What are the enforcement mechanisms that are included in this 401 certification as conditions? In other words, what happens if you don't do it?
Well, we've already seen, one, the state certainly can enforce against us, and because these are conditions of the certification, they're conditions of the federal permit. So once we get our core permit, the Corps and EPA can enforce as well.
Why would you include compliance as part of the conditions there in this federal permit via the 401 certification?
Well, that's ultimately in the discretion of the state to decide whether they think that's necessary. And as my friend has already said, they concluded it was not necessary because they have independent enforcement.
How do you get to that conclusion based upon past?
Well, because they have enforced. And Mountain Valley has entered a consent order and paid civil penalties in response to those enforcement
But
actions.
look what it took to do it. My question is, why wouldn't you put those enforcement mechanisms into the conditions?
I don't see how the effort involved, Your Honor, with respect, would be any different if it was a condition of the permit. It would create ambiguity about who's responsible for enforcement, and as the state describes in its brief, they wanted to preserve the ability to have that enforcement authority on their own. They have exercised it. Mountain Valley has paid civil penalties in response. That is substantial assurance that such a condition, making it a condition of the certification, is unnecessary. I've vastly exceeded my time. I'm happy to continue in response to any further questions. If not, we would ask that the court dismiss the petition for review. Thank you.
Thank you, Mr. Sibley. Tini, you have some time reserved.
Thank you, Your Honors. I'd like to address the mitigation framework just a bit. At JA 00210,
Are you talking about
Sorry.
this restoration work plan?
The restoration
that
work plan.
Council said that's all new?
right. That's inconsistent with the way the mitigation framework describes itself. At JA, I believe it's 128, MVP explains that its various requirements were scattered amongst many documents, and so the point of the mitigation framework was to bring them all to one place. At JA 0210, it says, stream and wetland construction and erosion sediment control measures are not addressed in this restoration work plan, except to the extent they specifically pertain to restoration. On the subject of condition 4, about the use of materials,
And that language was in there, correct?
that language is in there.
Yeah,
Yes.
Mr. Sibling asked me, I guess rhetorically, where am I getting that language from?
I believe it's from
I think
JA
he said he didn't know
210.
where you were getting
Yeah,
it from.
didn't even know where I was getting it from. Yeah. Go ahead.
Condition 4, the project-specific condition addressing, materials that MVP cannot use. That condition prohibits MVP from using household appliances as fill material. So I don't know that that was ever part of a construction plan. The list it seems to be more of a general permit condition that may have come from other permits and isn't project-specific. On the topic of continuous monitoring, the 2017 plan, erosion and sediment control plan, is in the JA, and at JA 2056, it provides that spoil placement and best management practices will be monitored at all times during stream crossing procedures once work within a stream area is started, and it will be conducted continuously to completion. I firmly believe that there's very little new here beyond the requirement that they provide additional compensatory mitigation, which is to pay for damage after it's done. On the question of whether
So you're saying that this restoration work plan that council cited, the document is new, but what's thrown into it is not new. It existed in some form in various other places, for the most part.
I believe that to be the case, with the exception of that compensatory mitigation, which is new, even beyond the new document. MVP described it as a compilation, and each time that something new has been presented, it's been able to be found in the prior requirements. Council argues that the reliance on EPA is not a sufficient ground for reversal because there were multiple bases, but it is not clear that DEP relied on any particular of its reasons independently and alternatively, right? And an agency action must be vacated if any of its grounds are infirm, if you're not able to find that independence, and that's the AES Sparrows case cited in our brief. DEP describes in the certification that its reasons must be taken together, so we can't parse them out at this time. Finally, DEP predicted that there would be no violations going forward, going to this question of how many is sufficient. Again, EPA has said that water quality standards must be met at all times. There is no substantial compliance doctrine under the Clean Water Act. DEP predicted no violations going forward, but simultaneously said that on a project of this nature, it would expect to see violations. in my final minute, I would just like to emphasize that it should be, and the law required, Section 401D required DEP, once it determined that compliance with the stormwater permit was necessary to meet water quality standards, if it believes that to be the case, that had to become a condition of the 401 certificate. Counsel for DEP says that preemption was the only, reason. We think that's a pretty important reason. We disagree. We think that the stormwater permit is preempted. But there is another important reason as well. Congress intended for these conditions to become part of the 401 certification to be sure that there are multiple enforcers involved. So that, if it is preempted, then the Corps or FERC could enforce if it becomes a condition of the federal permit. And importantly, Congress also recognized, and this court has echoed that in the Piney Run decision, that citizen enforcement is an important component under the Clean Water Act, and conditions of 401 certificates are enforceable in citizen suits. And so by leaving it out, not only does DEP expose its stormwater permit to the risk of preemption, it also short-circuits the various enforcement mechanisms that Congress intended. Unless there are any further questions, thank you very much.
Thank you, counsel. Thank you all, and we appreciate your arguments and your assistance in these difficult cases. And we would love to come down and greet you in our normal Fourth Circuit tradition, but under circumstances, we can't do that. But know very much that we appreciate you and we wish you well. And thank you so much.
Good morning, Your Honors.
Good morning, Mr.
Counsel.
Mr. Brandt.
May it please the court, my name is Jeff Brandt. I represent defendant appellant Roderick Williams. Mr. Williams' Rule 60B3 motion, although filed outside of the time limitation of the rule, was timely because equitable tolling applies legally, meaning that because Rule 60B's time limitation is an affirmative defense, equitable tolling applies, and it applies factually, lining up this court's case law on what is required for 60B3.
Deal with the legal determination that it applies to Rule 60B.
Yes.
In light of the Marsh case and the way it treated that particular issue there.
Well, our argument is that Marsh doesn't apply because that's about the federal rule of appellate procedure, but Your Honor, I think it's easier than that. This court has said in McRae, which...
Let's not brush off Marsh so easy. It did apply to it, but look at the reasoning. I mean, it looked at that Rule 4, definitely wrote, and it said, okay, it doesn't apply here, and then it looked at a separate rule and saw that it was accepted out of it, and then came to the conclusion that it didn't apply there. You kind of have a similar pattern here. You got a specific rule, then you got other rules that sort of doesn't include that 60B.
And
So don't brush it off, so easy on that, at least from my perspective, in terms of the rationale. Yes, two different things, but they're kind of talking, the rationale is the same.
Yes, Judge Wynn, and I think the rationale comes down to rule by rule, whether they're jurisdictional, claims processing, or affirmative defenses. Remember that it's not Rule 60B that we're talking about, it's the time limitation of 60B. And this court's case law in McRae has called that an affirmative defense. And this court's case law in Prescott, 221 F3rd 128, has stated that an affirmative defense is subject to equitable tolling. Our first...
Have we, I didn't find a case, have we ever done this in this court, granted, found it to be equitable tolling on Rule 60?
I have not found one, Judge Wynn.
How about other circuits?
I did not find one in a search on either time, before the reply brief or before this oral argument. But we're finding pieces where consistently the time limitation on Rule 60B3 is considered an affirmative defense, and then in other cases, not talking about 60B, consistently talking about affirmative defenses being subject to equitable tolling. Our first defense, no pun intended here, is that the government did not raise this issue below and has been waived. But even if not waived, and the district court didn't take this up below, we submit that this court's case law already settles this, albeit not in a published decision that talks about both Rule 60B's time limitation and the affirmative defenses are subject to equitable
I really
tolling.
appreciate your thoughtful answers to my questions. Okay, if you got equitable tolling, tell me about this 8 months that it took to file this motion after you received this new evidence. How's that going to work in your favor? I mean, even if you got it, if it does allow it, how are you going to get over that hurdle?
That it took Mr. Williams 8 months to file his motion.
That's right.
I would only say he's a pro se litigant prisoner without the resources of an attorney, without the resources of someone who's not in prison. I think his track record is exceptional when it comes to diligence. He's working as quickly as he can under very difficult circumstances, sometimes without a law library, sometimes in solitary by no fault of his own, just when the prison's on lockdown. I can't speak to, there's nothing in the record that tells me exactly what's happening in those 8 months, but the record does show that this gentleman is doing everything he can to get the evidence he needs to prove what he believes is true. And if it takes him 8 months in prison, that might take us 2 or 3 months on the outside. Either one's out of time.
And his efforts, in some sense, have been Herculean compared in terms of trying to get information from North Carolina and those things.
He's battling statutes that tell attorneys not to help him. He's battling agencies that refuse to disclose information to him. He's battling briefs that we're not accusing the government of malicious conduct, but briefs that misrepresent what's actually happening in the North Carolina Investigative Bureau concerning analysts and the accuracy of those analysts' tests and the credibility.
The problem with that is all of that was known, and then it took 8 months. He wasn't battling that after doing 8 months. He knew at that point he had this evidence regarding Bissett that was there.
Yeah, I guess I'd put myself in the shoes of Mr. Williams, and he finally has that smoking gun, and now he says, I better write the best brief I've ever written. And I bet that didn't happen overnight. What can I say, Judge Wynn?
I'm with you on the pro se. I mean, at some point in time, it seems as though someone who gets a lawyer, you ought not get a lawyer. You ought to go pro se if you think, because you're going to get more rights by just doing it yourself than if you get a lawyer. Get a lawyer, take 8 months, oh yeah, you wouldn't have been here. But you're basically saying, if you don't have a lawyer and you know that everything's there, that our rules, at least in the equitable tolling, if it applies, would be there. I mean, all this, I got it in terms of going back and forth with North Carolina, but that had already been done. That's the problem I'm seeing here.
The day I get to argue that court-appointed attorneys should be appointed for these types of issues, so we don't wait. 8 months will be one of my happiest days. But until then, we have to deal with the reality that you're an indigent prisoner fighting for yourself. You don't have the right to counsel. You don't have a family member who's going to write a check to an attorney if you'll find an attorney to take the case.
I have a question about the underlying facts. In your brief, you say that Bissett was fired or forced to resign from the SBI. Where is the record support for that?
I'm not going to be able to cite the JA, but that is going to come from the attachments that Mr. Williams filed in one of his 60B motions where they uncovered, I believe it was Attorney Heather Rattlade's.
Right. In her letter, she said, the attorney says that Bissett was fired or forced to resign from the SBI. She just says that. I don't see any record support, even in attachments to her letter, that Bissett was fired or forced to resign. Rather, it appears she retired. Now, there may be questions about the timing of her retirement. I was just wondering if there was any record support for that.
I'm sorry, Judge
No,
Thacker.
go ahead.
I don't believe we have authority beyond that letter.
All right, thanks.
I don't think it's that letter plus something. I think we're relying on that letter.
All right.
If equitable tolling applies legally, we move to equitable tolling applying factually. And the first element under Holland is diligence. I don't think anybody's questioned his diligence. The district court did not deny him based on a lack of diligence. The government has never argued he hasn't been diligent. It comes down to extraordinary circumstances. Unconscionability and a gross injustice if we were not to have this issue heard. If the 60B were not granted to allow Mr. Williams to finally get to argue that counsel was ineffective in these ways. It is not the same standard as the merits of the Rule 60B when it comes to misrepresentation, but there is some overlap. There's misrepresentation by the government, and the district court erred in failing to find so because the government made it sound like it knew for a fact. It had investigated and knew that there were no reasons to question Analyst Bissett. There were no reasons to question the SBI, and that therefore there were no reasons to question her credibility in her testimony, the credibility of the DNA report that she issued saying that this was Mr. Williams' blood, and therefore that misrepresentation means that Mr. Williams still has not had his 2255 ineffective assistance of counsel arguments fully litigated today. On this record, there should be no confidence that if the jury...
Didn't Mr. Williams know in March of 2011 that there were, quote, troubling cases that included Bissett and Barker?
He had suspicions, and I have nothing in the record to point to show that he knew. He has said to me he has, but there's nothing in the record to say that before that date he had knowledge. He had suspicions because his position is he wasn't even there. And if you're not even there on the date that, on that July date, that is the basis of counts 6 and 7, you're going to very strongly believe something's wrong with the DNA test that says you were there. On this record, there should be no confidence that if the jury heard reasons to doubt the scientific evidence, it would have not found Mr. Williams guilty. We don't, as I think the government seems to suggest, need to prove he's going to win his 2255 because we're simply saying that the Rule 60B should have been...
So what is your best argument that he wouldn't have been convicted absent the blood evidence?
Because the testimony conflicted on whether he was even there. And so the government relies on the DNA.
How did it conflict? You're talking about the probation officer?
Yes, the probation officer.
She saw him at 6 PM or?
Yeah, and the test-
What time was the shooting? What time was the crime committed?
I'm not remembering that off the
I
top of
don't
my
think
head.
it's in the record, is it? Or maybe it is.
My suspicion is it is, and I just don't remember.
Oh, okay.
But I will look at that
All right.
during the break, but
It must have been sometime around 6 PM for your argument to be that there's
that's correct.
conflicting. Okay.
Some 4 to 5, but I will look at that if you'll give me
Okay.
that chance, Your Honor. And I already forget where I was, but
You're talking about the aspect of it, what makes it unusual and
Yes.
unconscionable, you mentioned these words.
I can't think of to call this ordinary is either an admission of the government that things like this happen all the time, which is disturbing, or is worrisome that we'd have more cases like this and we just don't know about it. And Mr. Williams is extremely lucky to be in a position that he's able to find that evidence for what Chief Judge Gregory has mentioned as Herculean efforts to get the evidence. And if there are no more questions, I'll reserve my time.
Thank you, Mr. Brandt.
Thank you.
Ms. Greeno?
May it please the court, Elizabeth Greeniff on behalf of the United States. This court should affirm the district court's dismissal of Williams's Rule 60B motion as untimely. And before I address the mandatory claim processing rule, I'd like to address the significance of the district court's factual findings, because Williams' claim both for equitable tolling and his claim for relief under 60B both depend on those findings, showing that misconduct was committed by the United States. The district court did not clearly err in finding that the United States did not engage in such.
I think the threshold issue is whether equitable tolling applies to Rule 60B.
Correct, and I'm happy to go straight to that, Your Honor.
I was wondering why you wouldn't, because if you go there, I mean, why discuss all this if it doesn't apply? And I'm not saying it does or does not, but if we're the first time doing it here or in any other circuit, and I'm particularly interested in the Marsh case and its impact here,
Yes,
and as well as the Lambert case, and how that applies here, and whether in fact there is such a thing as equitable tolling for Rule 60B.
based on this court's decision in Marsh and the Supreme Court's decision in Lambert, I don't think that equitable tolling applies here because it is a mandatory claim processing rule. And what both those courts have said is that when you're looking at whether or not a rule is a mandatory claim processing rule, you have to look to the text of the statute and also whether or not the text leaves room for flexibility such as equitable relief. And here we know that there is no such flexibility. Rule 60C1 says that a motion under Rule 60B must be made within a reasonable time and for reasons 1, 2, and 3, no more than a year after entry of the judgment or order. And then when you look to Rule 6 of the Federal Rules of Civil Procedures, it carves out an exception when it talks about extending time, saying under subsection B, in general, a court may extend time for good cause. However, a court must not extend the time to act under Rule 60B. So given that you have...
You think that's like Marsh case on the Rule 4? They found another statute there that accepted that 4.
Correct. And under the Federal Rules of Appellate Procedure 26, that's very similar to Federal Rule of Civil Procedure 6, talking about extending the time. And that's exactly what the court was looking at in Marsh in deciding whether or not there was an exception carved out that made this rule inflexible.
Well, you know, is there a difference that we're dealing with a procedural rule there, and herein you're dealing with a matter of fairness? Are there different principles we ought to consider, notwithstanding the similarity in terms of the reasoning?
I don't think so, Your Honor. If you look at the advisory committee notes for Rule 6 from 1946, when that limitation, that time limitation was put into place, the concern there was finality. It was important that when you're dealing with a post-judgment motion, which this is, and the other, Rule 6 includes other rules like Rule 59, when you're dealing with something that would set aside the finality of a verdict, it's important to know that at some point that's going to be final. That serves the interests of finality.
In other words, we're gonna live with a year, no matter what happens. Once a year happens on Rule 60B, that's what you're gonna get. And then it's gonna be over.
As to subsections 1 through 3. And in fact, it used to be 6 months, so they extended it at the time that they put the rule into place to make it a year. But yes. So we would submit that equitable tolling doesn't apply here.
Well, your other side said, well, even if it does, assume it does apply, that, you know, the 8 months is something we ought to consider in light of the fact that, well, he's pro se and he's in prison. A lot of things are going on. A lot of moving parts are happening here. And that's a consideration we ought to take into account.
That's true, but if, as Mr. Brandt represented, this was the smoking gun that he had, he does not explain at all, and it's his burden in this context to show that he meets the equitable exception. It's his burden to show due diligence, and he has no explanation for that 8-month period. And this court has found even a 3.5-month delay in bringing a 60B motion may not show diligence.
Was that 3.5?
It was an employment case. I'm not sure whether he was pro se or not, Your Honor.
But Ms. Green, isn't this case different? Finality does not loom as large as it normally is. Normally, finality comes in the sense that, well, listen, you've had your time and you're going on and on and on. It's sort of the progenitor is solely normally the petitioner. But here, the moving part is disclosing and understanding what the science was that convicted this man and what implications there are. This is something different. And in this case, for example, was there any evidence that he was shot other than somebody said he was shot? I mean, for example, like the hospital records, I mean, was there?
There were 2 people who said that he was shot. One was the witness Ortiz for the United States who testified as to the robbery because he was one of the victims. The other was Malik Muhammad, who had seen him with a sling on, and Williams at that point told him that he had been involved in a robbery and gotten shot during that.
So that's the person who supposedly shot him didn't testify that he shot him, right?
Correct. I believe that there were 3 people who were victims of the robbery. I believe 2 of them maybe went into the wind after this happened, so we did not have testimony from those 2.
But did you have any evidence that physically that he was shot? I mean, you could do that. That's non-testimonial. You could actually look at his body, couldn't you? I mean, you took the time to get blood from him, right?
After getting a court order, yes.
That's what I'm saying. You could have done the same thing there. Because it's interesting that the person who took the picture couldn't identify blood on the plastic bag.
Right, but there was testimony not only from Officer Johnson, who originally noticed that stain on the bag, there was also testimony by Agent Barker that when she went to examine the bag to see whether there was blood evidence, that she could see it, that it was visible to the naked eye. So it wasn't just one person saying that.
What time was the crime?
The crime took place around 4:30 in the afternoon.
And so what about the probation officer's testimony that she saw him, I guess, at 6?
So the probation officer who testified, Pam York, was not actually the probation officer who saw him that evening. She said that her coworker, John Green, had gone by Mr. Williams' home around 6:39 p.m., I think.
How is that admissible? She's testifying about what another coworker had done?
I think there were records, so it was a written report.
All right, so John Green goes around 6 o'clock, and what does he see?
She testified that the standard procedure under that circumstance is to pull into the driveway, beep your horn, and wait for Mr. Williams to just stick his head out the door so that she could verify, or John Green could verify that he was there. And we also know from...
And did he verify he was there?
Yes.
Okay, I thought there had to be some other piece to that more than that.
No, but we do also know that he lived 20 or 30...
But we don't know, but that isn't evidence that Mr. Green saw his whole body and whether he was shot or not. He only saw his
Correct.
head and he wasn't shot in the head.
Right. And I think he would have
Is
been.
that your point?
Yes. So,
But why wouldn't the government want to clear this up?
well, Your
I mean,
Honor.
you got someone who, you're keeping the records from him.
Your Honor, I would disagree with that. In
No,
fact,
how you disagree with my question?
you're assuming that we're keeping the records from him?
Why, no, I said, why wouldn't you want a full disclosure about this scientist, your forensic expert, given how important this case is?
I
I mean,
don't,
just put this comment, I mean, you're the government, right?
yes.
And so the government ought to represent fairness and openness. You took this case as a federal case, right?
Yes.
So why wouldn't you try to get the state to say, North Carolina, we need to know this? A person's life and liberty hangs on the balance. Why wouldn't you? When he was in the prison trying his best to get this information, why wouldn't you be a partner to trying to get to the truth? And the truth could be hurting him. The truth is the truth. It's not defending him because you have a greater burden. Your burden is not to win. Your burden is to make sure justice occurs. So my question is, why wouldn't the United States government, with all of its wherewithal, try to get to the nub of this? Did you really look at this man when you didn't find him in the database? And then you said, court order, let's get his blood. And then you examine, oh, that's him. And on the same week, right? I mean, I don't know what the evidence is. Is there evidence that the same week, or is that not in the record? Some of this, it's not in the record, it is in the record. But the point is, you take these cases from the state, why shouldn't you have to, why wouldn't you?
Well, I want to make clear that the evidence that you're talking about, I think, which shows that the set may have switched or mislabeled two samples, that evidence that happened didn't come out until 2005, which was after the time of trial.
Oh, I know that, but in terms of the process post-trial, why aren't you a partner in trying to get that out so that you can have that? Isn't that important to a person's life?
When we're dealing with the post-conviction context, this is a civil proceeding. Mr. Williams was already fully and fairly convicted. He's already had his chance to appeal.
You say he was fully and fairly convicted?
That is the presumption once he's had his conviction and it's been affirmed by this court on appeal. Then he's bringing a motion to vacate in which he carries the burden of proof. So he has to come forth with the evidence to show that there was something wrong. And we're not trying to cover anything up.
North Carolina said he couldn't get it. My question to you in terms of why didn't you help? That's a simple question.
Sure.
Yeah, just whatever the answer is, why wouldn't you help?
We don't have a burden in the post-conviction context. The Supreme Court has said this in the Osborne case from 2009.
I think the point is the government's burden is to see that justice is done. That's the burden. So why wouldn't you help?
Because and Ms. Ray will tell you this, we did not have that evidence, and it is not the normal course of events. Not that we don't act with honesty and integrity and try to reach the right result in every case, but in this particular instance, you have 13 different claims of ineffective assistance of counsel. We're responding to what Mr. Williams argued in those motions, and everything that we said.
Are you saying at the habeas proceeding for the Rule 60 that the government at that time did not know that the bloodstain was tainted or that the evidence confirming it might be unreliable?
I am saying that, and I don't think that Mr. Williams has shown even today that evidence was unreliable.
Where was the information of this at that time? In other words, it's one thing to come in, of course, counsel may not know it, but that doesn't make you blind to asking those that do know it. Was there not an investigation or something going on at the time, or was it something new?
Are you talking about with respect to the SBI?
Regarding the habeas proceeding, was there anything going on at that time when the representation is made, there's no evidence that there's any taint to anything, Was there anything going on with the law enforcement agency to indicate to the contrary?
I can't speak to that. I was not involved with this.
Wouldn't it be the duty of the government to know that if you have something going on, I mean, because who else, I mean, you got the SBI, you got all kinds of agencies there. If you get up in court and says there's no evidence, aren't you essentially saying that there's nothing there? That law enforcement, no one has found any indication of that, because representation was made. There was no evidence that the blood stain was tainted or that the evidence confirming that it was Williams' blood on the bag was unreliable. But you knew there were general issues with the SBI, did you? That's the nub of this question. It's really going there. You might not know the specific, but you knew something was going on with the SBI at that time.
So the information that he provided, Mr. Williams provided with respect to the newspaper article was talking about issues in terms of blood pattern analysis and in determining whether a substance actually tested positive for blood. But what it came in at trial in this case was the actual DNA analysis. And I want to make sure we're looking at this as well in the context of this is an ineffective assistance of counsel claim. So it's important to go back to what his attorney knew at the time of trial. And he has to make that showing in order to obtain relief. And I don't think that any reasonable jurist would have felt compelled, given the evidence.
Too, isn't it? What he knew at the time of trial is determining on what's being told to him. I mean, even the lawyer in that perspective can't make a motion, you don't have any information, but the point I'm asking on the habeas proceeding, at that time there was an SBI investigation going on and it involved Bissett. We knew she'd made some mistakes there. But for the government to stand up and say there's no evidence that this blood was tainted or that the evidence was unreliable may technically be true, but it's true because maybe you aren't looking or maybe you didn't ask.
Well, Your Honor, I do take issue with you saying that it's a misrepresentation. I mean, even if you're saying it's technically true, all of these statements were made, and the district court found this, in the context of responding to Williams's argument for relief under 2255. And he has the burden in that proceeding to make the showing. So saying the article identifies problems at the SBI's laboratory, talking about the article, does not suggest that the DNA testing was deficient or inaccurate. That's a true statement.
Technically true, you're right. The problem is there's a lot more to that statement that has not been disclosed. And yet, how are you gonna carry a burden if you don't know and all the information is on the other side? And they aren't telling you.
It's not an easy burden, and it's not supposed to be. This is not a chance.
It's an impossible burden. When you think of it in that light, you've got a burden to come in and say there's evidence. You've got all the other evidence on the other side. You got people who know this stuff, but you come in and says there's no evidence of it, nothing here. And you're right technically, because technically there is no evidence in the court because we don't know what's going on outside.
So a habeas petition at 2255 is not a chance to retry the case. It doesn't involve reopening all the discovery, looking at everything that's already been done. You have to preserve resources at some point. And in this instance, all we were doing was responding to the allegations he made. He has the burden of proof. I'm not saying it's an easy burden to meet. It's not, but that's by design.
You never answered Judge Wynn's question. The question is, he said at the time you made the representation that there was no evidence, didn't you know that something was amiss as to this SIB in terms of the examination of the blood exemplar, right? That's the question. Would you answer that question? Did you or didn't you know that there was something going on about that lab and that examiner at the time you made the forget about what that representation means. The question now is temporal. At that time, did you know, and you, not just you, the United States government, know that there was some problems with that lab and that examiner? That's a yes or no question.
I don't believe so. I believe the answer is no.
You don't believe so? Are you based on kind of your knowledge? I want to make sure how you qualify in your response.
I can't speak for everyone.
But you have to, because you represent the United States today.
Well, I don't want to make a
And the Fourth
misrepresentation to
Circuit
you.
never- No, the Fourth Circuit never
I know.
accepts that answer as, I didn't try it, I wasn't a lawyer. You're the United States here.
I did not know it. I know Ms. Ray did not know it when she made the representation in the underlying submission. That's all I can tell you, Your Honor.
So you know nothing about officers, officials, in terms of investigators, nothing like that? What they knew, you don't know?
I'm not sure. You're asking me, do I know about
I
investigators?
mean, you don't know what there was never any discussion in terms of, something is going on in terms of, about North Carolina in that situation. That was totally surprising to you, the news article, all that, correct? That's what you're saying?
I'm sure someone was aware of it.
Someone, I mean, you need someone in the United States government, prosecution, investigation.
Given the frequency with which we probably use the State Bureau of Investigation, I would say yes. But again, I'm not.
Isn't that attributable to you, the United States? If law enforcement knew that?
If law enforcement knew it, yes. I do, again, want to emphasize the fact that the particular evidence you're talking about did not come out until after trial.
Oh, I know. That's why we're talking about it at the time of representation,
Okay.
right? That had to be.
I want to go back just for a minute to the Rule 60B, where my colleague suggested that the government had waived its defense by not raising the untimeliness of the Rule 60B motion. And in fact, we did raise that timeliness issue before the district court. What I said in my brief was that we had not argued that equitable tolling didn't apply, but we obviously are raising that issue now. I also want to talk just briefly about the underlying North Carolina statute that Mr. Williams claims prevented him from obtaining this information. If you look at North Carolina General Statute 126-23, that statute wasn't amended until 2011 to place that restriction in terms of employee records on incarcerated individuals getting that information. So there was a period of time where he could have gotten that information. And in fact, he requested it in 2010. That's when he received the information from the SBI. So that, I don't think, his making a FOIA request to the state and expecting
So he
them.
had that information at least as early as 2010?
Correct, yes.
Which information did he have in 2010?
He had the information that
She retired?
she had retired and the other person was on administrative duty. And he put in his submission.
And how does that help him?
Not why the other person was on it, why they retired and were on
It
it?
did not. But if you look at Government SJA 642, he did argue in his original 2255 that the timing of that showed that showed misconduct, and
He argued that in 2011.
correct.
And the United States government didn't get involved at all in trying to figure out why she was retired at all? Is that right? That's a representation today to the court?
I would imagine we did not. I don't have personal knowledge of that. I see that my.
Imagine that they wouldn't do that?
I would not think so. So personnel records of the state are protected by state law. Once the criminal case is over, I'm not sure how we would get the access to that. I see that my time is up. If there are no further questions, we would ask this court to affirm the district court's decision.
Thank you.
Thank you.
Ms. Greener.
Mr. Williams respectfully submits that the government wants to use Ms. Bissett when she has some information that helps its case, but doesn't want to share when it turns out that the exact same week that she's testing the evidence that it used in its case, she made critical errors, and that wasn't her first mistake, it wasn't her second mistake, it was at least her third mistake. Mr. Williams argued in his 2255 motion that his attorney was ineffective for failing to test the blood and for failing to research Bissett and the SBI's past and its mistakes. he was prevented from getting that claim fully vetted in the
How
district.
would counsel at the time of trial have known about past mistakes?
He might not have known, but Mr. Williams requested that his attorney investigate, and it turns out that her mistakes dated back to at least 1999, which did predate the trial.
He requested that at trial?
He
Of
requested,
him at trial?
he requested that of his attorney.
Right.
Yes. And in the record, that's only shown from Mr. Williams' sworn
And he
filing.
did so because, as you said, he said, I wasn't there, so how in the world I don't care if the best, I'm not speaking for it, but the logic of it is, I don't care if the best blood expert in the world did it. If I'm alleging, well, I don't know if it's true or not, that I wasn't there, something is wrong. So, I mean, I could see why he would say, it's consistent. Listen, you better do something with test to that because I wasn't there. I don't know whether it's true or not, but that would be the framework of saying even a layperson at trial would say, you're my lawyer, but I'm telling you this, that's got to be wrong.
And the government's statement found at JA 133 was that the evidence the evidence that Mr. Williams alleged existed to show that he was correct, the government's response is that that there's no reason to believe that this evidence, quote, that the petitioner's blood on the bag was unreliable. There was no reason to not believe that. And we respectfully submit that that's not a technicality, true or false. That's simply false. When my colleague mentioned what I was trying to say about waiver, the waiver argument is that equitable tolling was not raised as an affirmative defense. Yes, timing, of course, was raised because the rule gives us a time limitation. The government, of course, raised that. What we're saying is the government didn't raise the equitable tolling affirmative defense below and waived that. I didn't finish my answer to Judge Thacker about why there's reason to believe that the DNA evidence credibility was important to the jury was not only the conflict of the testimony, but it was also because there was testimony that there was only one man seen running away from the scene. And the government's case was built around two men running, and one of them is Mr. Williams. And as for the equitable tolling applying as a matter of law, and what Judge Wynn apparently is wrestling with, like how do we find that equitable tolling applies? Is there a reason to believe that equitable tolling applies? I think the rationale might even be found in the Supreme Court's Holland case and the fact that we're applying equitable tolling to habeas generally. And Holland's about 2244. And we're finding equitable tolling in this court applies to 2254, 2255. And if Rule 60B is meant to reopen a habeas, any of those numbers that I just gave, any of those statutes, if it's meant to reopen those because there's a problem in the integral, I can't talk today, in the integrity of the proceedings, why would it not be right then to apply that same equitable tolling to 60B to reopen what we were saying equitable tolling could be applied to make sure the right result occurs in that underlying habeas. And Holland at 646, if it helps.
And then if it does apply, Judge Wynn also asked about the 8 months. What was your answer to why the 8-month delay?
I've got nothing in the record that I can point to say because that simply wasn't fleshed out. I think our best argument is the district court judge didn't deny us on diligence because look how diligent he was. And we haven't gotten a factual ruling below. Now what do we want, right? I guess we're gonna ask that the court find that the district court erred, find that equitable tolling applies as a legal matter, find that equitable tolling applies factually to the law, remand with instructions that are consistent with those rulings, that the district court find that he's not only allowed to make that argument, he's timely and he wins his 60B so that the 2255 is reopened. And if there's any matter that keeps Mr. Williams from getting to that point because the district court judge dismissed his equitable tolling argument in a footnote, summarily in a footnote, claiming Mr. Williams did not even argue equitable tolling, even though page after page is about Holland and how he meets equitable tolling, traditional equitable tolling, we would ask as an absolute last resort that the district court hold an evidentiary hearing. If this court has any questions that he can't win because there's not enough facts, why are we not having an evidentiary hearing? And it's because the district court is not even letting him get to that point. It's simply saying summarily in a footnote, you lose. The man has never had this core issue litigated. He's been blocked at every turn, and we ask for justice, and I appreciate the court's time.
Thank you, Mr. Brandt. Thank you, Ms. Green. And Mr. Brandt, we particularly want to highlight and thank you for your service as a court-appointed counsel. We rely upon lawyers like yourself to do that, particularly cases and appreciate your fervor in the case as well in terms of representing those who are indigent and require court-appointed counsel. And of course, Ms. Greenough, we thank you for your able representation of the United States. We'd love to come down and greet you, but we cannot do that. But know very much that we appreciate your arguments and your helping us on these thorny cases. Be safe and be well. Take care.
Thank you, Your Honor.
We'll have our final case for this morning.
United States versus Gloria Taylor.
Oh, you need a cover for the mic.
Mr. Mercer?
Thank you. Good morning. May it please the court. Steve Mercer for Gloria Taylor. This case involves trial counsel's ineffective assistance by failing to file a suppression motion based on the DEA's use of administrative subpoenas to collect Ms. Taylor's cell phone location information that revealed her wholesale movements over time. Now, repolled data, which is at issue in this case, is information that Ms. Taylor had both a subjective and legitimate expectation of privacy in. And there's really three main reasons why.
Why are we, just to set the context, we're focusing on the repo data as opposed to the entire warrant and the basis of it? What's the basis of that? Why are we here with just the repo data as being the matter that's on certification to us?
So the reason why is that when the subpoenas issued for the Ms. Taylor's cell phone information, that was in 2014. January of 2014 at JA 955 is the subpoena. Under 2703C, well, let me step back for a minute. The Stored Communication Act really functions in a tiered system. And so a subpoena can be used to obtain basic subscriber information without notice to the subscriber. The subpoena can. But if content or information akin to content is to be obtained from the carrier, the government must use an order under 2703D. And so to fast forward a little bit, in the relevant procedural context here, Graham 1 had been decided, which held that a subscriber holds a legitimate expectation of privacy. The Fourth Amendment applies to cell site location information that was being obtained under a 2703D order less than.
Wait, Graham 1 had been decided when?
Graham 1 was
It was decided in 2015.
Yes.
And when was the subpoena?
The subpoenas were in 2014.
Okay.
When I say relevant procedural context, I mean while this case was pending, so about 8 months before trial, Graham 1 had been decided. And so Graham 1, of course, ultimately affirmed the conviction under the Leon good faith exception, because even though the 2703D orders there predated Graham, it held that the Fourth Amendment applied to this type of information. So
Right, so assuming the Fourth Amendment applies to repoll data information, when Graham 1 wasn't issued until 2015, why doesn't the good faith exception apply to this case as well, since the subpoena was in 2014?
For three reasons. One is that
Three reasons.
there is no third-party wrongdoing. So here, the officers erred.
Well, the officers didn't ask for repoll data in their subpoena, did they?
No, they did not specifically mention repoll data. At the same time, however, under the SCA, Stored Communications Act 2702, the carrier cannot voluntarily provide information to the government.
So that's your number one, the third-party violation.
Yes, that the agents erred because a subpoena was used that triggered their coming into receipt of this information, the repoll data, which we maintain cannot be obtained by subpoena.
And you're saying the agents knew that the subpoena they used, even though they didn't ask for repoll data in that subpoena, would have triggered the receipt of repoll data? How did they know that?
Well, a couple reasons why. Number one, they knew that because they used it as such, right? When they got the repoll data, they used that location information in the application, a later application for a 2703D order for the cell site location information. So they obviously had experience with that data because they used it. And given the volume that law enforcement collects of cell site data in general, I mean, we cited to one, publication that indicated well north of 1 million in a particular year requests for cell site data. So if Sprint is doing this on a regular basis, which it appears to be the case, a well-trained officer would recognize that.
Well, the subpoena didn't just ask for subscriber information, it asked for telephone connection records in the 2703C.
Yes.
So how did they err by asking for those telephone connection records as provided by statute?
And they can ask for the connection records. We don't dispute that. The error here is that what they received from Sprint was location information. And that location information is more akin to content than to connection records. Connection records would be the originating number and the number being called. Because, otherwise, and this is certainly true as of 2014 and well before that, sort of rewinding to what the issues were that were in play at that time, it was really between was a 2703D order required to obtain location information, or was a probable cause warrant required?
Well, you got the 2703 statute there. It talks about the connection records. What you have here is repolling data, which basically is a phone switch, tells you how you connect a call. How is that not connection records?
Well, it's no more or less connection records than cell site location tower information. And still,
Far less specific, isn't it? When a cell phone tower pings you, you're in that location. This data here, what does it tell you? You're in a state, or you're in a general area or somewhere?
Your Honor, it absolutely is less precise, but as Carpenter made clear, and I believe as Graham 1 also made clear, it's not just precision, it's quantity. And so we have here a vast quantity of data, over 382 days of data, repoll data, were obtained by a series of 3 subpoenas. In Graham, it was 221 days of data, Carpenter was 127 days, and Jones was 28 days of
But
data.
that's not repolling data in Carpenter and Graham.
To be fair, that's correct. It obviously,
Big difference in that CSLI type stuff that they can pick there and repoll it.
Jones was GPS, of course. Carpenter addressed the argument that, well, this is less precise. And of course, we're talking about sectors, not precision information like GPS. But here, and really drilling down even further, Your Honor.
What is it telling you? What is this repolling? I mean, every time I do one of these cases, I learn a new term. Something different. What's a repolling data? I'm thinking, is it like a switchboard the old days where they plug in those plugs up there? What is that?
I think the best analogy is it's the brain for a group of towers. And so if we're going to protect the specific tower that a cell phone is connecting to, we also have to protect the brain that regulates that group of towers in a region.
So how general is the region? How big is this region you're talking about?
Well, it varies, of course. You know, New York City may have, if you go through the repoll index, there may be 3 switches. If you go out
Well,
to,
the entire city of New York City?
well, Long Island, that sort of area.
So you would know a person's in Long Island. You would know they're in Manhattan. Or you might know they're somewhere on the other side.
Yeah, so
That's it.
density,
That's all you'll know.
yes, density. But here's the important thing, though, Your Honor. What you know is when there's movement. And it's not just location that we're concerned about in this context, but it's location coupled with movement.
So you could know one day he's in Long Island, next day he might be in Arizona.
Correct. And it's encyclopedic in the sense that, and the government raises this point, well, you know, airline records, okay, well, but a cell phone is always attached to a person. So it's like in the push of one button, the government can get.
It's like a GPS, only in a broader sense.
I'm sorry, Your Honor?
It's like a GPS attached to us all the time, only in a broader sense.
Absolutely. And that's what's so unique about the cell phone and why it's encyclopedic. It's not like you're just guessing at what airline the person may be on and getting those records. This would
But
cover.
big difference. GPS tells you you're moving while it's going on. You're just rolling out. This doesn't tell you that. It tells you, boom, you're here. Then you make another call, you're there. But it doesn't tell you while the call is going on that there's movement going on.
I'm not suggesting that while a call is moving on, a call is ongoing.
It's not even close to GPS.
What I'm suggesting, Your Honor.
GPS is something that scared the Supreme Court so much they didn't want you to put that on a car.
So-
It went home.
So what is your most succinct argument that the use of this repoll data is an invasion of a reasonable expectation of privacy?
Because of what it can reveal about a person.
Okay, and what?
And what it can reveal, a person's interstate travels and travels within a state between major cities or locations can reveal an awful lot about the person. So for example, if someone lives on the West Coast in California and they're a member of a political organization with perhaps extreme views that has a meeting in Michigan, and you see the data from the switch indicating Michigan, and then you see data from Washington, D.C. on, say, January 5th or January 6th, that is going to reveal a lot of information about that person.
Well, tell me this. If you get on a car in New York City and you drive to North Carolina, you're going to hit a few where you won't get many tolls in North Carolina. But before then, you can hit a lot of tolls. Can the government subpoena those toll records from each one of those booths that do basically the same thing you just said is happening here?
Yes, I believe they could, but think
What's
of
the difference?
Well, the effort involved and the practical limitations, right? So if the government doesn't know how someone is traveling, they would have to get records for all the different Easy Pass or like toll records for vehicles. They'd have to get train records, bus records, and every single airline. Here, all that's involved is literally a fax, a push of a button to a carrier with an administrative subpoena, right?
So the ease of getting the information is important, even though ultimately the result would be the same.
Yes, I think one of the factors that
It's too easy for the government to get it this way, as opposed to that toll booth, which is the same thing. Now, you get on that, you come through there, that toll booth is lighting up. It knows you've come through there, whether it's Easy Pass,
Yes.
especially Easy Pass. They know that they have it, but they can get that.
right. Yes.
But you're saying it can't get the repolling data that you made a call in New York, then you made one in Delaware, then you made one in Virginia.
Right.
And that's all you got.
And that's because of the unique nature of a cell phone and how it's attached to us. And that the government, at one touch of a button, there's no practical limitations to gathering all of that data that reveals a person's interstate movements and movements between major cities. And there's other scenarios that we can think of, particularly in a post-Dobbs world, for example, too, where there may be interstate travel between a pro-life and a pro-choice state that may be of interest to law enforcement. And again, at the push of a button, send a fax. The next day, they get the person's, what is supposed to just be basic.
You're not getting us into that argument today. But let me ask you now. So, because it is interesting, that toll thing kind of troubled me a little bit, because when I think about it, and I think about Carpenter, I think about Graham, I actually dissented in the Graham case where they gave it on our farm. Took Carpenter to get it back somewhere in that. And I think the court is still struggling as to what to do with these technological advances. But this one in particular, because of this fragmented way in which it's given it, you say ease is the way to do it, and that sounds good, but no one else has ever said that ease is a factor in determining these kind of cases.
I think Justice Scalia discussed it in Jones, Your Honor, because there's the reality of trying to follow someone, right? The police conducting surveillance, and when police do surveillance, and I just had a hearing where it was all about.
Again, we're talking up in Zonja, you're talking about a GPS that you tap to a car and follow it around and around and know every last place that person goes. That's a different ballgame than a camera that's picking up from one street to the next street. It would be like the camera is following you. You put it behind it, you just have the camera going behind it. That's a different thing.
Well, here's the point I was hoping to make, is that if it's just a question of police manpower, to surveil someone takes a lot of manpower, right? So there's a practical safeguard right there against the government overreaching, because if they do a surveillance, they need 8 or 9 officers to be following someone 24/7 and switching cars so they don't get spotted. They're just not going to do that on a widespread basis. But I think one of the themes that has always emerged when we talk about technology and surveillance is that those practical limitations are gone. And now the government, with very little effort, can obtain enormous amounts of data, which it then filters through with its, software
And
programs.
then uses to obtain a search warrant.
and then uses to obtain additional information, for example, the 2703D order here, and then the GPS orders, and then ultimately the search warrant for the residents. And I have a red light flashing, so.
I just want to ask you just a question, and it's, because I thought that's what Judge Wynn was asking you, why we just here on the repo. But the fact that they went into her yard and with a dog without a warrant, that's not here at all. I mean, is that just eschewed by the defense that wasn't? I'm just wondering. I mean,
Yeah, that is not within the question.
oh, I know. I know. That's why I
Yes.
said maybe just a housekeeping question.
It-
Maybe counted to jurist curiosity. Why is it not here? I mean, why is that gone? Why is that gone? I mean, they didn't have a warrant. All of that stuff, you just went to the house without a warrant and put a dog in her yard and alert, and then they get a warrant to search the truck.
Oh, I think it's even more so than the yard. The dog went into the garage.
Exactly. Even more so. Well, that's my point.
Well,
why is it
within
not
privilege.
here?
Well, because it was raised, and Judge Schwang in the district court considered that motion would have some merit under Gruninger, but that there was a good faith exception that applied under Collins, because Collins v. Virginia, which, you know, addressed the police entry to examine a motorcycle, you know, under a sort of a shed, an outdoor shed attached to the house, had been decided. So there was a good faith issue that Judge Schwang, I would anticipate
I
we're
thought
going.
good faith came with warrants.
I'm sorry, Your Honor?
I thought you applied for a warrant and it turns out that it's defective.
Well, yes,
A warrantless search gets good faith if it's wrong?
I would anticipate that if we're successful and we obtain a remand, that we're going to continue to press that issue, because we don't believe that the.
That issue may be, I don't know. I'll stay on that one. But anyway, go ahead. That's all.
So I'll reserve any balance of my time for rebuttal. Thank you, Your Honor.
Thank you. Mr. Salma?
Thank you, Your Honors, and may it please the court, Christopher Sarma, on behalf of the United States. The government would ask that the judgment here be affirmed. Trial counsel provided effective representation of counsel. In 2014, when law enforcement officers obtained this repo data through an administrative subpoena, they did so legally or, at minimum, as Judge Stacker pointed out, in good faith. And even if the district court had ruled that the use of repo data should have been suppressed, there's not a reasonable probability that the outcome at trial would have been different. And I think one thing I want to highlight at the beginning is I think there are some difficult questions potentially as to whether repo data falls within the definition of historical CSLI under Carpenter, and I'm happy to discuss those. But for the purposes of deciding this particular 2255 motion, I don't think the court has to get there because of the good faith exception and the fact that every court that seems to have addressed the question of when you've collected CSLI data prior to Carpenter, does the good faith exception apply? And every court has said, yes, it does. And I think that ends the debate here about whether or not a motion would have been meritorious.
I have a separate question. Without the repo data showing that appellant used the phone in Arizona, what information in the government's 2703D established the connection between appellant and the target phone?
So if you look at the 2703D, the other, which would be, I have a JA 912 to 916, the other information was there was a tip from the Tucson DEA to the DEA in Maryland, where at the time in which the suspicious package or crate, which ended up having marijuana in it, was sent from a shipping depot in Tucson to Maryland. A rental car was photographed outside the depot. That rental car was matched to a rental car that Ms. Taylor had rented. In addition, there were the Southwest travel records, and you can see a table that was used both there as well as in the search warrants that show that she was traveling to Arizona and on dates in which marijuana shipments were being shipped from Arizona back to Maryland. In addition, there's evidence that when she returned to Maryland, there's evidence that she had spoken to a particular driver at R&L Carriers, Mr. Willis, and she had eventually disclosed, and she had given him specific directions about where to deliver these packages. And so those would be the other points to place her in Arizona.
That connect her to the phone? That was my question.
Oh, sorry.
That was my question.
The phone in particular, the connection is there was a subpoena made to Avis to see what phone she had given to Avis when she rented the car, and that was the phone number that was identified. I think it's the 957 number.
Okay.
And so just going back briefly, because I want to start with the good faith exception. I think even if the court
It would be nice to address the Fourth Amendment issue here because, that's something that can come up again. It seems to me to be fundamental. We can jump right to the conclusion. The Supreme Court has done that to us in 1983 cases and other things. Just jump over the big issue and go, the Constitution, go right ahead and just resolve this and leave it hanging out there. Then come back and have to deal with it when it's more direct. Is that where you're going with it?
I'm happy to, I'm always happy to have the narrowest ruling, but I'm also happy to address it right now, Your Honor. And we would submit, for some of the reasons that you described in your hypotheticals.
It's right there in front of us. And yeah, it may be the answer is down here on good faith, but that issue is right in front of us now. How do we, but you want us to skip over it. That doesn't help you on the next case, doesn't help the defense lawyers on the next case. Wouldn't it make life a lot easier to know that answer and not have to keep bouncing that one around?
We would welcome it, Your Honor, but I would say for the purposes of this particular case and this particular ineffective assistance of counsel claim, I don't think it gets there, but
So, repoll data is not CSLI, but what is your best argument that the use of repoll data is not in and of itself an invasion of a reasonable expectation of privacy?
I think because it falls within the third-party doctrine, right? It's being voluntarily conveyed. I actually was reading.
Well, so did the other things before they didn't in Graham 1 and Carpenter.
So I think, and I was actually reading Judge Wynn's dissent, luckily, in the en banc in Graham this morning, and he actually, I think, specifically talks kind of incidentally about the difference, right? With CSLI, there's no voluntary conveyance. I'm holding my cell phone in my pocket. It is trying to ping for TAO records, and that's how you get all the different types of kind of pinpoints about where you're located. In order for you to get any sort of switch records or switch data associated with where you are, you need to make an outbound call. So if you actually look at the the repo data in this case as an issue, when Ms. Taylor is making an outbound call from Tucson, it's hitting a switch in Phoenix and then being routed. But if you look at calls that follow after that that are inbound while she's still in Tucson, they actually don't go through the 449 Phoenix switch. They go through the switch wherever the person making the call is located. I think that's a key difference here. So I think this is much more akin to, for example, Smith versus Maryland, where the court said you're voluntarily conveying the numbers you dial into a telephone. That falls under the third-party doctrine. I guess the other example would be IP addresses, right? The court has said several times that you're allowed to, that is a voluntary conveyance to a third party. And so you don't need to, there's no Fourth Amendment search, even after Carpenter, for IP addresses. And an IP address is much more granular in terms of its ability to locate someone than repo data is. I think, I'm not sure it was clear in Mr. Mercer's remarks, but the repo data here showed that when she made an outbound call in Tucson, it hit a switch in Phoenix. So if we were to go to a court just on that information and said, well, we know she was in Tucson because it hit a repo, hit a switch in Phoenix, I'm not sure any judge would have given us, a search warrant. We had to have much more, specific pieces of evidence linking her to Tucson itself in order to get there. I would add on the question, the meaty question the judge would, I'm happy if the court were to address it. The only case that we found, and I think both parties found it, that really gets to the nub of it is Commonwealth versus Collins, which is from the Supreme Court of Massachusetts. And I think it's a good analog. It is pre-Carpenter, but the Supreme Court of Massachusetts got there before the Supreme Court of the United States did, and they said, in a prior opinion, Commonwealth versus Augustine, that historical CSLI was indeed a search, and so therefore you need to go out and get a warrant. And then Collins comes along, and they say, with repo data, and they're talking specifically about repo data, they say that is not the type, it doesn't have the granularity to it, it doesn't invade on privacy such that it's a search within the Fourth Amendment. And so we would ask that the Fourth Circuit follow that ruling. I guess the other case we would rely on would be United States versus, I think you pronounce it Zahadis, from the Second Circuit, where they're kind of factually similar to here. There was a request via subpoena for telephone connection records. The telephone company returned information, including what they referred to as location information. I think there was country codes, and the court said there, motion denied and judgment affirmed. And I think I've not heard from the other side a case going the other way on repo data, so I'm not sure the basis to do so here, especially because I think there's several distinctions as discussed between repo data and the historical CSLI from Carpenter.
So going back to my question about the 2703D order, was the repo data used in any way to obtain that order?
Yes, Your Honor. So there, and this is at JA 914, there was a single sentence about the repo data. It said, cell phone data routing numbers show that Taylor utilized this phone in Arizona during the time frame of October 9th and 10th, 2013, and January 22nd to 25th, 2014. And
you got that phone number in the first instance from issuing a subpoena to the rental car?
That's correct, Your Honor. And we would maintain, and this kind of blends into the second argument that we raised in our brief, that even if you were to excise that information from the 2703D order, as well as it was used again in the phone tracking warrant, we would say we would have still been able to obtain those warrants and that D order based on all the other information that we provided that located her specifically to Tucson and that shipping depot where the packages were coming in, as well as testimony from the delivery driver about how she was instructing him about where exactly to deliver these packages to. I'm well under time, Your Honors, but I think I've gotten to the main points I want to address. Unless there are any other questions from the panel, I'm happy to rest at this point.
I do have a question. I'm sorry. I just want to make sure I understand about this repo data. Did you say earlier that she made a call from Tucson, but the repo data, the number attached to it said was Phoenix?
That's right. The number that the repo number that you can see is 449. That's associated with, I believe it's either a Lucent or a Nortel switch located in Phoenix, because that would be the closest switch in which to route the number when she's calling someone back on the East Coast.
So but it doesn't tell you she's in Phoenix. It tells you she's in Arizona.
I think as a technical matter, it says that when they are routing the call, the tower used would be the switch used was the switch located in Phoenix. I think there could be examples, and I'm not a telecom lawyer, so I apologize, where you could potentially be on the border of the state, and I imagine there could be a situation where the way that the way the call is being routed is hitting a different switch.
DC, Maryland, Virginia area.
Right, it could hit in a bunch of different places.
Do we need to resolve the question of whether this repo data was properly obtained under that statute of 2703C to rely on the good faith exception, or is it enough for us to say the DA relied on a reasonable interpretation of the statute?
I think I think Your Honor, I think we would say that the statute allows, as you pointed out, for telephone connection records. This piece of information is a telephone connection record. And there's no, I'm not sure I've seen, and we were not cited to from the other side, any case law suggesting that this isn't a telephone connection record. It's a switch.
Tell me a little bit more about this repolling data. When I think of the CSI, and one of the big questions, one of the big differentiations seems to be, one's a little less precise than the other. You're unable to do it. But if you go out into the rural areas with that CSLI, it's about the same thing as repolling data, isn't it?
I'm not sure that's correct, Your Honor. For example, I believe there's only one switch in Hawaii. I think you would get more precise location data because there's presumably more than one tower in Hawaii. I imagine there's actually several in Honolulu, for example, or in other kind of even more remote areas of Hawaii. So if you had I think the CSLI would be more granular. I do think there is a difference too about the conveyance, right? The problem, I think the thing that you pointed out in the dissent and then that Chief Justice Roberts then pointed out in the Carpenter majority is with the CSLI, the only thing you're voluntarily doing is turning your phone on. And given how everyone has their cell phone on them at all times, there's really no way to avoid that. Here, you're making, Ms. Taylor or any other defendant is making a choice to dial a number, right? And so that is the voluntary conveyance that's taking place. And when she makes that outbound call, she's revealing something. I think she's revealing that it hits a switch.
See, Carpenter had a catch-all sort of view there, and you gave me Hawaii, and I was thinking Montana. That seemed like to me.
And I was thinking West Virginia.
I'll say I clerked in Fairbanks, Alaska, so I'm well familiar with the...
That's what you call a rule. So if you're talking about a cell tower being pinged in Montana and repolling that, it looked like to me it could be the same thing. And that's the question I'm asking. That was why I brought it up. It wasn't for Hawaii. Hawaii is a nice place, but I don't think it was being ruled at all. Not even West Virginia in some spots.
I would imagine...
Montana.
Yeah, I imagine there's only a couple, and I'd have to look back. I don't have the Sprint. I'd have to look back to the Sprint log, and you can do so yourself. But I imagine there are very few switches in West Virginia, or there might be one in Alaska, but there are a lot of towers, and I think the CSLI is going to pick up all those towers. But even, and I know Your Honor wants to address the issue head on for purposes of future precedent, but here, as Judge Thacker, has asked me about, there was a lot of other independent evidence in the record to show that she was in Tucson and she was at that shipping depot at the relevant time period. I think that's important to remember when deciding whether or not the motion to suppress would have been meritorious in this case. Nothing further. Thank you very much, Your Honor.
Thank you so much. Mr. Mercer, you have some time left.
Thank you, Your Honor. I think using granularity to distinguish Fourth Amendment rights is problematic. It would result in a system where, for example, people who live in a rural area have fewer Fourth Amendment protections than someone who lives in an urban area. And that can't be right. And so it's not about granularity. Granularity is one factor. It's not just about precision. It's about quantity and ease of collection. And ultimately, we maintain that a reasonable expectation of privacy and a subjective expectation of privacy is really revealed by what the data tells about a person. And so someone, for example, who is traveling every weekend to Las Vegas, who is maybe running for office and claiming to be a family man, those frequent trips to Las Vegas may suggest something about them. Or if someone is traveling to the city where a Democratic National Convention or Republican National Convention is held, again, that's going to reveal information about someone. And ultimately, the quantity is so important because it's patterns, right, that can emerge from travel and movement interstate and between cities. And that's what really informs subjective and legitimate expectations of privacy. And the government makes the point that, well, this is not like CSLI because it's being voluntarily conveyed when someone dials a number. Well, I would take issue with the government about CSLI. CSLI, the pings occur when the phone call is connecting. And so, this is the argument that was always made in the CSLI cases by the government, is that there's voluntary conveyance. Somebody has to dial the phone number to then connect to the tower. But it's that connection to the tower and that the significance of that data that is just invisible to the user. I mean, who knows about repull data? And so it's the lack of knowledge under CATS that information is readily and easily available to the government at the push of the button that's so problematic. Judge Thacker, you had asked about the 2703D order at JA 912 and had, I think, focused in on the question of, the 2703D order was, the target of that was the 757-945-6589 number in connection with a 841 offense. And so the question is there specific articulable facts in the 2703D order that target phone is being used in connection with an the offense of an 841? There, as I read 912, 913 to 915, there's nothing in there about Avis. And there's no other information in there about 6589 being used in connection with the 841 offense other than at JA 914, subparagraph 3E, which, as the government had read, cell phone routing numbers showed that Taylor utilized his phone in Arizona during the time frame of October 9th to 10th, 2013, and January 22nd to 25th, 2014. And so what that was establishing that was so critical to the 2703D order for that phone is that it was being used around the time where the government believed that there was activities occurring related to 841. And so that is what provided the basis for the 2703D order. And then once the government had the cell site location information from that order, then it was able to obtain GPS tracking orders and prospective surveillance. So I think...
So it all goes back to this repull data, not a subpoena to Avis.
Yes. Because it's the repull data, and this is the location, and it's the movement, right? It's the fact that she's not in Maryland, she's in Arizona with that phone, that target phone that is providing the articulable specific factual basis for the 2703D.
But in terms of ground information, wasn't there evidence that at the depot in Arizona, the car was located by camera?
There was an indication that around, I think it was in July of 2013, that there was a vehicle that Ms. Taylor was in that was outside of the shipping depot.
Right.
It was a tip. It wasn't known.
No, it doesn't matter if it was a tip or not, but there's evidence that the car was there in the area, correct?
Yes.
And then when they checked the license plate of the car, they found out where it was rented from, and then from that rental agency, they found out the application or the paperwork done for the rental, correct? Right?
No,
That's not right?
no.
Oh, go ahead.
It's part right and
Tell me the part that's right.
okay, the part that's right is the sequence of the investigation. But the phone number, the target phone number for the 2703D order at page J8912, that phone number was initiated after that July surveillance in Arizona.
Okay, before they knew about the rental.
After.
That's
In other
what
words,
that's what I said, they knew about the rental before, didn't they? Am I wrong?
Yes, but.
Yes, I'm wrong. I mean,
No, I'm sorry. What I'm expressing, Your Honor, is that the basis for the 2703D order for the 6589 number, the 6589 number didn't come into existence until after that July tip. And so my point simply being is that in terms of the basis for getting the 2703D order for that phone number, which provided the data that was then used to get the more specific GPS orders and ultimately to get the search warrant for the phone, for the home, the basis for that connection between 6589 and the 841 offense is the repoll data, which showed that that phone, we're not talking just about Ms. Taylor, but that phone was being used in connection with the offense because it was traveling with her. That's the point I was trying to make. And I don't believe I made it very well. But the other point I would just, my clock is going up, so I will stop there.
well, if you want a final point to Senator about something that's on the threshold of utterance, go ahead.
As of 2014, the prevailing practice was that location information was obtained with 2703D orders or search warrants, not subpoenas. And so there's no Kroll good faith exception because the DEA officers did not comply with the statute in this case, which includes receipt of information that the carrier could not, under 2702, voluntarily provide. Thank you very much for your time, Your Honors.
Thank you so much, and thank you both counsel for your arguments here today. We can't come down and greet you, but know very much that we appreciate your arguments and your assistance on the case, and we wish you well. Thank you very much, and I'll ask the deputy clerk to recess the court.